and welcome all to today's program on why access matters. This is the fifth in a series of Berkeley Judicial Institute programs on issues of particular concern to judges and the press. And in putting these programs together, we have relied heavily on two people in the audience, District Judge Marcia Krieger from Colorado and the Administrative Office of the Courts, Charlie Hall. So we thank them for the inspiration, and we're grateful to be involved in this series. Forgive, please, a quick Berkeley Judicial Institute advertisement before we go on. Now that we have you here, whether it's your first time here, as is true for some people on the list, or you're one of our cherished regulars, come on back. Check out our website where you can register for future programs. You can watch and listen to interesting things. Watch, listen, and read. That would be a good word. To interesting things. Consider joining our mailing list and following us on social media. Advertisement over. And now, the real reason you're here today. And I should say, Justin will put the links to Berkeley Judicial Institute in the chat because I know you'll desperately want to follow us and do more with us. To lead our conversation today, we are so lucky to have as moderator NPR's justice correspondent, Carrie Johnson. She has an equally impressive panel. The Washington Post's James McLaughlin, Bowman and Brooke's Jodi Schebel, and Judge Joshua Wolson from the Eastern District of Pennsylvania. I promise I could talk about these four forever, but I bet you'd rather all hear from these four. So again, Justin will put the biographical links to this accomplished group in the chat, and we will get started. So, Ms. Johnson, where do we begin?
Thank you so much, Denise, for this opportunity. Thank you all so much for joining us. We're here today to talk about public access to the courts, and it's so important. You know, these rights are enshrined in the Constitution through the First and the Sixth Amendments. They're so important now when we talk about educating the public about the judicial system, about fairness and transparency, and also about instilling public confidence in the courts when we know that at least for the nation's highest court, public confidence is at a rather low ebb, according to public opinion polls. So our goal for today is to talk a little bit about some of the central issues that come up before judges and litigants, for reporters and members of the public who want to attend court proceedings, gain access to certain materials and documents, and also to potentially create historical records or historical studies of what specific judges and courts and cases involve. And so it's my goal that we'll have a conversation, kind of a wide-ranging conversation. We're planning to leave about 15 minutes for your questions at the end. But without further ado, I'd love to begin, and I'd love to begin with the issue of what exactly access to courts means and whose access we're talking about. And I'd like to start with Jim and then bring in the rest of the panel.
Sure. Well, thank you, Carrie. And I'm happy to be talking to this distinguished group. What access means, well, first of all, whose right of access is it? It's a public right of access. So I obviously represent a news organization, and we think about media, press access to court proceedings all the time, but analytically, there isn't any distinction between the public's right of access and that of the press. The press have rights of access to the proceeding just as a member of the public, regardless of their status as a member of the press. There are situations like with limited seating or credentials where, decisions have to be made about who gets admitted to a courtroom, but the starting point is that court proceedings and judicial records, meaning records filed in litigation by the litigants and also opinions by the judges, are presumptively public. It's a qualified right of access, so it's not absolute. It varies somewhat depending on the type of proceeding. So the right of access is at its strongest in criminal cases and especially criminal trials, although the US Supreme Court has held that there is a constitutional right of access to voir dire, to preliminary hearings, not just a trial. And lower courts have recognized both a common law and constitutional right of access to other types of proceedings. But something like a grand jury, for instance, does not have a right of access, a public right of access associated with it. It's also more limited in juvenile proceedings. So the starting point is, the presumption is that what happens in court is accessible to the public, but meaning either attending it or getting access to transcripts, or if it's a court that allows broadcasting or webcasting or whatever, which is not legally constitutionally required, but is allowed by some courts. But the public does have a right to, presumptively, to attend court proceedings and to look at what documents are filed with the court. So not discovery materials, but records filed with the court, which might include some discovery materials. So that's kind of like the scope of it. And then the reason, from my perspective as a press lawyer, that it's important is kind of partly what Carrie mentioned, which is instilling public trust in the courts. I mean, the basis for the public right of access, according to the Supreme Court, is that access actually there's a historical practice, tradition of access, but also it actually improves the performance of the courts in the long run. It's an experience and logic test. And in the long run, the public is going to have more faith in an institution that it can monitor what's happening in, and mistakes, when they're made, if they're not made in public, if there's no ability for the public to see what happens in a proceeding or why it happened, then the legitimacy of the courts as an institution is damaged. So that's the kind of very short version of why traditionally courts in the US have recognized the importance of public access.
Thank you so much, Jim. And I'd love to bring in Jodi. Jodi, you routinely work on access issues, but you also represent clients who may wish, for certain kinds of reasons, to limit access to certain kinds of court filings and proceedings. Can you speak to the issue from that perspective?
I think you're muted, Jodi.
You'll need to unmute.
Jeez, right away, first time.
We have never had a Zoom where someone didn't need to do that. So thank you for being the first.
Absolutely. So my practice is largely developed around the representation of corporate defendants, manufacturers. And from a corporate perspective, those companies that develop and sell products to consumers, they spend a considerable amount of time and money developing those products, and they have an interest, and it's actually a property interest that allows them to protect the documents and materials that they create related to the development of whatever product that is that they're manufacturing. And because they have a property interest in that material, essentially, when they get sued, and materials related to a product or documents related to a product are requested from the other side in litigation, say, somebody's injured in an accident and they want design and development documents, what did the company do to ready that product for market, or financial information about the cost. Each corporation has a right to maintain that information as confidential. That right may give way to the right of the public under certain circumstances, but it's always a qualified right. It is not an absolute right by the public. And a court, which is why we have Judge Wolson here, who can step in, any court can, upon a request from a litigant, either deem that materials are confidential, seal a record if necessary, seal a courtroom, which is a rather extreme circumstance. But there has to be an appropriate showing by the party seeking to seal or to keep those documents from the public. And that showing typically has to be, that there's a harm to the corporation or a harm to the company that would result from a financial harm that would result from those materials becoming public. As Jim said a minute ago, there is a difference between materials submitted on a discovery dispute or a discovery motion. Typically those, most courts have determined that there is no public right of access to that information. When you get to trial or you get to substantive issues in the case, maybe even with respect to experts, there, the public starts to develop an interest, and that again can be overcome under certain circumstances upon an appropriate showing by a manufacturer, which the public can then object to. So there's a give and take, and that's the court's role to determine the manufacturer's request for confidentiality over materials as compared to any public right that there might be to access in those materials.
Thank you so much, Judge. You in how many cases are the decider and the one who does the balancing? How do you address these issues when they come to your desk?
Well, start with the idea that I'm not a rubber stamp, right? So people come in and they say confidential, put under seal, and the challenge with these motions, we're talking about sealing motions in particular here, is that typically, most things in front of me are resolved through an adversarial process. There is no adversarial process on these because the people who are affected aren't here, to Jim's point, right? It's the public. So occasionally maybe there's some case where the press is here, and they have their own interest and they're sort of serving as a proxy for the public, but 98% of the time that's not the case. So I have to take a somewhat searching inquiry on my own. I try to be mindful of the requirement, as Jodi just said, that you have to show a harm. And at least where I sit, the Third Circuit's been pretty clear that harm, first of all, the harm can't be very generalized. Can't be, well, I will just be harmed because my competitors will know this, right? You have to explain what the competitors will do with it. And sometimes that's really easy. I always say there's two great trade secrets in the world. One is the formula to Coca-Cola, and the other is the recipe for Thomas's English muffins. And if that's what's at stake, that's what's being asked to be filed, you can simply file an affidavit that's 4 paragraphs that says no one else knows this, and it gives us a competitive advantage. And if someone else had this recipe, they could duplicate it and they'd compete with us unfairly, right? Done. But you got to show me that. And in a lot of cases, it's a little more complex than that, but not much more complex than that. But I need to see it. And so I think the key for us is we do pause, we take a breath, we take a really hard look to make sure that that showing is there in every motion to seal that's in front of us.
Thank you, Judge. And in a few moments later in the program, we'll discuss some specific issues and circumstances. But before we get there, I'm just struck by the idea that we're doing this panel on Zoom. And since the pandemic, so much of what courts do has occurred on Zoom or by telephone. And how do you view these access issues in the context of Zoom? How do you deal with that in your day-to-day job as a judge?
It's a good question. I try to remind everyone that Zoom, particularly Zoom, I don't do a lot that is what I would say other than routine scheduling and case management, where I'm not terribly worried about public rights of access. And that's not on the record typically. But if I'm on the record, I'll do it by Zoom. I very rarely would do it by phone. It's just not an effective way in my mind to do it. It's court. Right. I mean, and that's kind of what it comes down to. It's court. And so I expect the same rules of decorum. I expect people to be dressed like it's court. I expect, I've had people roll their eyes at me and I say, I can see you, right? And things like that. So, it's if people want access to my Zoom proceedings, I will make it available. The one thing I will say is, if I have a hearing in person, an order goes out that says the hearing's at this time in this place, and come one, come all, essentially, right? I don't do that with a Zoom hearing in the sense that I don't post the Zoom hearing will take place at this link, because there is a fear of Zoom bombs and other bots and things like that. And I would say it's less a function of trying to keep the public out as much as, again, if you think about the analogies, if I have a courtroom, I also have a court security officer sitting in the back, and he can maintain decorum and keep an eye on what's happening. And maybe I have less of that with a Zoom hearing. And so the mechanism I have is I just post an order that says there will be a hearing via Zoom. We'll provide the parties the link. If anyone else wants the link, please contact Chambers. And, you know, as I said, we've had times where people have contacted Chambers for that. We're not shy about giving it out, but that's kind of the balance I strike on that front.
Jim, as someone who so often represents the interests of his own media organization and sometimes engages with others through coalition work, and as someone speaking for myself who always wants information as quickly as possible, there's a complication here, which is that maybe we're not going to get immediate access to certain things, but we will get access down the road. And I wonder how you think through those issues with your reporters at the Post and in the coalitions that you're a part of.
Well, yeah, always, as you know, as a reporter yourself, Carrie, the newsroom, it's a demanding client for a lawyer, and they always want things immediately. And they always think that whatever they're doing is like the most important thing in the world right now. And God bless them for it. But, you know, we push for access as quickly as we can. You know, we understand sometimes it's not going to be possible logistically to get, and I'm talking about records here, with actual attendance of court proceedings. Of course, we want, you know, somebody in the room. And in a case like the Trump trial in New York, where there's massive interest, the courts will do overflow rooms and that sort of thing. But for access to records, we push for, it depends kind of on the type of record too, but we try to get contemporaneous or near contemporaneous access. But we understand that, you know, that's not always possible. Like I sort of always mention the Moussaoui case, the so-called 19th hijacker as an example. I think of the court handling massive interest really well. Like Judge Brinkema in that case, you know, worked with court administrators to make all of the exhibits that were shown in open court available. I think it was either that same day, like at the end of the day, or maybe it was by 9 o'clock the next morning or something. But there was a process in place to make hundreds of documents available to the public without having to go request them from the clerk's office, which then becomes a huge burden. So now most cases aren't like that, as Judge Wolson noted. Like most cases don't have that level of interest, but for cases that do, we try to work, you know, preemptively with court PIOs and judges, or, you know, whoever, chief judges, and come up with like a media plan where if we know that there's a high profile trial that's going to happen where there's going to be dozens of different media organizations there, it's in everybody's interest to raise the issues early on, weeks, if not months ahead of trial, and as much as possible to agree on here's the process for trial exhibits. Here's the process for who gets to sit in the courtroom versus the overflow room. Each organization gets to designate one person or whatever it is. And there's still always, you know, disputes that happen along the way, but we really can narrow the range of issues on which there's disputes massively when it's not like done sort of at the last second or as it happens. And I think, you know, most of these high profile cases nowadays, it's routine to have somebody from the court, you know, working with a coalition of media lawyers or media representatives and trying to sort out these things as much as possible in advance.
And Carrie, if I might, I feel like that what Jim said is so important, because the idea of cooperation between counsel and the court representing the people, as the judge pointed out earlier, is really what needs to happen. It's It's when you are preparing for trial as a part of your pretrial order or whatever pretrial conferences you're going to hold with the court that media access gets raised. And, you know, what documents are going to be, what documents are each party going to claim confidentiality over? Maybe it's social security numbers, maybe it's other things that just should not be. And there's you know, federal law that governs and protects that information. The public does not have a right to access that information. Maybe it's other confidential material that either the court has previously agreed to seal or agrees to, you know, hold in abeyance until after the court understands how the evidence has come in a case. But you have to have some cooperation. You have to raise it to the court. You have to have that conversation early and often before trial starts. And that's really what keeps information flowing and puts Jim in a good position to be able to get the information he needs, whether it's at the start of the trial or contemporaneous with the evidence, or, you know, 30 to 45 days afterwards, if there's a motion to seal that the court hears.
And I just want to add to that too, because you know, Jim's describing these cases where maybe it's readily apparent that you're going to need this process in place, right? And you know, courts often have contingency plans in place for that. What are we going to do? Because every court deals with that at some point. But you know, as with every situation, fire drills are harder and what lead to mistakes, right? And we are now in a world where there are you know, various online portals who have people, and some of them are small, but some of them are bigger outfits, Bloomberg Law and Law 360 and so forth, who have people just kind of roaming the courthouse and looking for something interesting to sit in on. And, you know, so if they walk in to, you know, a hearing or a trial that I'm having, and the lawyers say, well, we don't know who's in the back of the room, and now we want to go under seal, and we haven't talked about it, it's much harder. And, you know, and the reality, the practical reality of this for probably a lot of people watching is, you know, I've set aside some amount of time for this on my calendar. And it's not like, you know, my calendar is like a Jenga tower, right? If I pull one brick out, the whole thing collapses. And so, you know, I don't want to then have to say, all right, wait, we need to have a 2-hour hearing unexpectedly on this issue that I haven't even thought about, not only on the big picture issues of, you know, does this stuff go under seal, but the really granular mechanical stuff of what are we gonna do, which is hard to figure out. And so I think, you know, in every case, I tend to ask at a final pretrial conference, do you guys have reason to think anyone's coming to watch this? Do you know of industry publications, for instance, who might be paying attention? Things like that can help me flush out what to expect. And even then, you know, as I said, you know, there's 29 judges in the Eastern District of Pennsylvania, including our seniors. Third Circuit's in our building, so there's always reporters wandering around here. And you know, in a lull, they may just set up shop in the back of my courtroom.
Absolutely, Judge. You're warming my heart with that, because one of my earliest experiences here in Washington was entering a courtroom in federal court and the judge closing the courtroom and me standing up without any real knowledge or insight and declaring myself to be a reporter and objecting to the idea that he was about to seal the courtroom. Now, I think Jim can help us all with what one should do in that situation, but there's nothing that will make a young reporter more suspicious, more skeptical than somebody trying to close the courtroom as soon as they walk in the door, basically. Jim, what do you think?
Yeah, the Reporters Committee for Freedom of the Press actually has a little script that reporters can, you know, carry around if they need to, where they can say something that is reasonably coherent if they find themselves being kicked out of a courtroom. The advice we give is, if you're being kicked out of the courtroom, and you can just call us, the lawyers, but you can also ask the judge for permission to be heard and identify yourself and object to the closure of the courtroom on the grounds of, you know, the First Amendment and or common law rights of access. We try to keep it very simple, and then just comply with what the judge says. And if the judge says, okay, fine, but you still have to leave, don't get arrested over it. You know, comply with it. And sometimes judges will say, well, do you have counsel who, you know, I'll give you an opportunity to be heard on this in an hour or whatever. And I've actually gone down to the Superior Court and the federal court spur of the moment to argue these impromptu motions. Or sometimes we'll move for access, after the fact, we'll move to unseal the transcript or partially unseal the transcript. The one thing we do push for with the courts always is at least an explanation of why this is what Judge Wolson was talking about there, and Jodi for that matter. There has to be some publicly available statement of why this happened. It's definitely not acceptable for a judge just to say, we're going to close these proceedings, period. So sometimes we'll ask for the order closing the courtroom and review it. And occasionally I've told our newsroom, like, I think it was a legitimate closure. They're talking about the identity of a confidential informant or something. And so we shouldn't move to get this information. We don't really have a right to it. And sometimes we do make an issue of it. It really just depends so much on the situation. But we God bless the reporters who are willing to stand up. And I've had reporters like basically argue a motion, not really knowing what they're talking about, but like successfully, on occasion. So, there is like a language available to reporters who just want to basically note for the record that they are objecting and ask for an opportunity for their counsel to be heard.
Jodi, I've heard you say earlier that there are, in your view, many legitimate reasons to request to seal not just the courtroom, but to seal certain filings, trade secrets, other things that would affect the business and the business operations of your clients, but also maybe national security issues, somebody who's a cooperator with the government. How do you go about making that case before any reporter knocks on the door, shows up in the courtroom? Is there a standard motion that you tend to file in those situations?
Yeah, I think there's actually two. So the first would be a motion for entry of a protective order. So when a case is first filed and we understand that our corporations, our clients' confidential information is going to be requested in the process that is called discovery, where the parties exchange information. So when we know that confidential information is going to be requested, we typically try to negotiate a protective order with the other side. And that says it essentially governs two things. It governs the recipient's use and sharing, if any, is allowed of those documents. And second, it may govern both parties' ability to file those materials under seal, usually before trial. Sometimes trials included, usually not. But the protective order, the motion for entry of a protective order, and then the protective order itself will set forth those standards and allow specific parameters under which receiving party can use the materials, what they can use them for. They can share those documents with their experts. They can include them in motions or papers that get filed with court. And then also allow sealing if something is filed with the court. Separately, sort of later on, you might have a motion to seal, which would be a different motion. And a motion to seal could either ask the court to seal a particular document or set of documents. It could seal a specific portion of a document, redact a piece, a paragraph, a sentence, whatever it might be. Or it could ask that the courtroom be sealed, as both Jim and the judge have mentioned. That does happen from time to time, where a party may ask that the courtroom be sealed for the reasons that I think have already been identified. The burdens under the rules to get either a protective order entered versus a motion to seal are very different. Usually it's a good cause standard to have a protective order entered early in the case, to have discovery materials, non-substantive materials kept from the public, in a sense, maintained as confidential, and a much higher burden, as the judge alluded to, when you are seeking to seal something that is substantively used. So yes, Both of those mechanisms exist, and I think I wouldn't call it standard. I think it's case by case. Every time the facts have to be specific to your case, they have to be specific to your documents. You've really got to focus in on what support you have to, generate or warrant the action that you're requiring or asking the court to take. You want to give the court the evidence it needs to rule in your favor. And the other side obviously is going to, come up with whatever it can to say that your evidence is insufficient and sealing or the motion for protective order should not be granted. But those are the main two mechanisms that we use to maintain the confidentiality of documents.
Judge,
I
I want to
think-
bring you back in here. Thoughts?
Yeah, well, I mean, I was going to say, I think that one of the things that Jodi just said, which is really important, is the distinction between the protective order and the motion to seal. And, I don't really have much of a dog in the fight on protective orders. They frankly make my life a lot easier because I'm not going to get a bunch of people calling me saying, this particular document we want to produce is confidential, et cetera, et cetera. And, I think everyone understands the public doesn't necessarily have any right of access to stuff that the parties are exchanging privately in discovery. The key there, though, is that that line often gets blurred. And the way it gets blurred is that I will frequently see people submit to me protective order motions where the protective order they ask me to enter says anything marked confidential shall be filed under seal. And the problem with that is you've now kind of jumped from inquiry 1 to inquiry 2. I don't know what I have just authorized to go under seal. And, I practiced before I came on the bench. The reality that I know is that everything in discovery gets wildly overmarked as confidential because it's just easier. And because frankly, again, the parties don't have much of an incentive to fight about it because they're all going to see it. Right. And so, I can't bless it at that stage. I need that subsequent motion to seal. And the Third Circuit, at least where I spend my time, has said you have to look at each individual document before you place it under seal. And so if I'm doing it at the front end of the case, then I'm not fulfilling that obligation. So I will, and I tell the parties this, I will file or I will sign a protective order that says you have to seek leave to file under seal any material that is designated confidential, because then I can look at it and rule on it, but I won't file one that says you have to file it under seal. And then the one other piece of that, and I tell the parties this as well, is, and this is just, it drives me a little batty, is I'll get from one side a motion to seal that says the other side marked this as confidential. We don't really know why. We don't really think it's all that confidential, but under the protective order, we have to move to seal it. And I look at it and go, what am I supposed to do with this? And so I always tell the lawyers, and I tell them right at the outset, like, look, this is one of those times where you all are going to have to work together. I know you're opponents, but if you plaintiff don't have a dog in the hunt as to whether this is really something that should be sealed, but the defendant cares mightily, then a couple days before you file it or a week before you file it, pick up the phone and call them. And by the way, don't tell me that there's some huge advantage. Everybody knows by the time you're going to file for a summary judgment, for example, which documents you're going to use. And so tell the other side, hey, I'm going to use this. And I'm going to have to seek leave to file it under seal, and I probably need an affidavit from one of your folks. Can you get me that so that I can do it, right? And just work together, because otherwise you're kind of foisting the work on me, and I don't like when people foist the work on me. So, it's just a very practical tip, but it's one I keep reminding the lawyers of again and again so that it's on their minds.
Absolutely. And, I wonder, this is a question for all of you. Reporters often take note and do stories when a courtroom, for instance, during a trial is closed for a long time, or significant swaths of evidence or documents seem to be sealed. I'm thinking in particular of a big antitrust trial that took place here in Washington, D.C. involving Google, and there was a lot of media coverage actually about how much of that case wound up being under seal. I'm not sure if that media coverage influenced the behavior of the participants or the judge, but I think it may have. And I wonder to what extent you think that's appropriate, and whether to what extent you think that having the outsiders, the public, newspapers, magazines, radio stations might influence the behavior in those decisions.
Could I take a crack at that? And I'm sure the others will want to weigh on this too. The sort of stereotypical perception has been, going back to the O.J. Simpson case, frankly, is like, the courtroom will turn into a circus if and that really was largely about televising, not just public access, but actually access on television. But like, I do think, I mean, I would certainly agree that in the O.J. case, it influenced the way everybody acted, the prosecution, the defense, and probably Judge Ito as well. But there's also lots of examples where I think the parties and the judge, performed the way they would have normally, or even maybe arguably did a better job because they were more conscientious, more accountable, because they knew the eyes of the world, were on them. I think I won't mention specific cases, but I think the O.J. case set the cause of public access to trials back like a decade or more, and especially televising trials. But like, there have been plenty of examples of press coverage not resulting in proceedings turning into a circus. And if the judge does a good job and is experienced and, keeps things under control, it really shouldn't turn into the Lancey, the circus, basically.
I think one of the things I think I heard you ask, Carrie, is the question of whether it's appropriate to write about the access issues themselves. Sort of like it's almost like this sort of meta commentary on the process. I mean, to me, whatever decisions I make are subject to public scrutiny, including the decision about whether there should be public scrutiny, right? And so I don't see why it should not affect things. Now, whether it should affect the outcome, which I think was the other half of what I heard you ask, I would hope the answer is no, with the caveat being that, again, I rely on an adversarial system. And so, I do my best to look at the materials that come in front of me and to say, are these really, confidential? Is there really a harm from publicizing them? But I'm getting sort of a one-sided view. And, I trust the lawyers in front of me, but they have clients to represent. And so I do my best. And then in the sort of unusual case where I get some adversarial requests saying, hey, this is wrong, let us tell you why, or the balance is different than you realize, Judge. It's not just about the abstract interest in access, but let us tell you a little bit more about the balancing. That certainly would change or could change the outcome because I'm getting specific arguments. But I would certainly hope that the notion that, well, gee, someone might be watching and the commentary, oh, they really are watching, isn't changing the outcomes, because I think as judges, it goes back to the sort of the public confidence point at the outset. We should be doing this all the time and paying attention to it all the time, as though the public's there. And again, Jim's talking about this in the context of reporters. My grandfather, when he was in his 80s and living in Center City, Philadelphia, and he and my grandmother loved each other and were married for a long time, but he often liked to get out of the apartment and not be with her during the day. And he would take a walk down to the courts and watch. And he wasn't going to stand up and make an argument about. He might have smacked the guy with his cane to tell him not to close the courtroom, but he wasn't going to get up and make an argument. And it's open for that viewing as well.
And Carrie, if I can, I think that the other piece of this is that sort of every circuit in the federal circuit handles confidentiality issues and sealing maybe slightly differently, right? There's precedent in every circuit that has to be followed. And what happens in Texas might be slightly different than what happens in Michigan. We have the First Amendment, our sealing laws are grounded in the First Amendment, whereas in other circuits, it might be focused on the common law. And I think Jim mentioned that earlier. So, it isn't a one size fits all. Every court is bound by the precedent that exists in that district, and by which they're obligated to follow, including obviously all of us, US Supreme Court precedent. But if somebody says, well, I got access in this case, in this state, under these circumstances, it might be analyzed differently by a different case and a different court in a different circuit under different precedent.
Thank you so
With
much for
different
that.
facts. Yeah, with different facts too. Yeah, absolutely.
We have a number of judges in the audience, and so I'd like to round the corner on this panel by asking Judge Wolson to talk about best practices and the way he handles these issues and the way he tries to anticipate them early as they come onto his desk and docket.
Yeah, I mean, we touched on some of this. A lot of this goes to case management generally, right? So it's a conversation I have with the parties at the outset. That's, first case management conference. But it's in my written policies and procedures, which are posted on our website. This is how I deal with motions to seal. I've published some opinions about it, and I remind people about that. And I frankly, I get out and speak about it whenever I can too. So these are things that I try to do to keep it top of mind. Once we get into the case, I've told my clerks that these motions are a priority. That often they can be resolved quickly, although occasionally they can't. And one of the challenges is the case where, you get a motion with, here's the 59 redactions we want to make to, our 64 exhibits and things like that. But even then, just at a very granular level, I have told the parties, for example, that when you submit stuff for sealing, I need highlight that shows me if you're proposing. First of all, remember, redaction is better than sealing, right? Than all out sealing. And if you want to redact stuff, I don't want to have to guess at what it is. I don't want to have to kind of look at the page and try to figure out. And don't say to me, oh, it's the third paragraph starting with the word obviously, right? I want to just see it in yellow or pink or something like that where I can look at it. And if it gets to be more than a minor administrative burden to sort these motions out, which sometimes it does, then I will come back to the parties and I will say, look, lawyers, it's on you. You need to make my life easier. So go through, number all of your proposed redactions, and then give me a table that gives me the ordinal number, the quote that you're proposing to redact, and the justification. And I might give you a limit of like 150 words. Tell me why it should be redacted and point me to the evidence in the record that you've given me that shows that there's an actual harm, right? So things like that, some of these case management tools I find helpful. If it gets really out of hand, and this has only happened, I think, twice. I've been here 5 years, or 5 years now. It's only happened twice. But I will say to the parties that you guys are barreling towards a special master, and you're going to get a special master, and you're going to pay for it. And nobody wants that, and I find that very quickly I can, usually separate the wheat from the chaff in terms of which things they really care about and which ones they don't. And I just want to pause. So that's motions to seal. There's kind of two other issues that float around with these things. One is motions to proceed anonymously by a plaintiff. And that's right at the beginning of the case typically. And I deal with those often in like employment cases and things like that. And, there is case law that says the public has an interest also in knowing who's, litigating in the courts. And that makes some sense. And so, we deal with those. Again, those are just straight motions. I don't know that I have any particular granular tips other than to be mindful of them and to be aware that it's an issue. And that one thing I do know is that often lawyers will file they don't know what to do. And I understand why. So they just file the complaint anonymously. And then it's on me to sort of spot, hey, where's your motion? And then the last thing is closing the courtroom, which we talked about some. It's obviously a much more extreme outcome. There's some simple ones where it's like, hey, there's national security interests at stake and things like that. When it gets to civil cases and it's about trade secrets and things like that, one of the things to bear in mind is it is a First Amendment issue. It's not just a common law issue. And because it's a First Amendment issue, it's a issue where the party seeking to close the courtroom has to satisfy strict scrutiny. So that means not just show me it's a compelling interest, but also show me that you're pursuing the least restrictive alternative. And I take that second part very seriously. All right, let's think about what we're doing here. Is there something we could do other than closing the courtroom? So, for example, I go down to Delaware. I do a fair number of patent cases to help out down there where they need help. And, the lawyers down there always want to close the courtroom during trial. And I'll say to them, well, wait a minute, do we really need to do that? Well, we're going to talk about our source code. Okay, I understand your source code's confidential, right? And certainly if you're going to put it in as an exhibit, I get the need to seal it. But do I need to close the courtroom for it, right? Like, why don't you take the line and a half of source code you care about and put it on an overhead and project it on a projector? It's going to look like gobbledygook because nobody really knows what it means anyway. And then we've avoided closing the courtroom over this because you're not talking about the whole source code. Things like that. And I generally find somewhat grudgingly that the lawyers sort of acknowledge, yes, that will work. And so, again, this goes to the case management. Let's flush this out, at a file pretrial conference. Are you going to ask me to close the courtroom? Why? About what? What else could we do instead of closing the courtroom? And, again, sometimes it's a case where it turns out nobody's paying attention, but I never know. And sometimes competitors are paying attention. And although that's what that's what gives people like Jodi the heebie-jeebies, it's also, they're allowed to come watch too, except in rare circumstances. And so, and they may get valuable information if it's, because on the one hand, it's a competitor, but maybe they're not getting competitive intelligence. Maybe they're getting information about some serial plaintiff who, is being a problem. These patent cases, I had one against a copier company and it was RICO. And then I know Xerox's lawyers were coming to watch because they were in a different district getting sued on the same issues. So, all of those things are things where I think the key is think about them, be aware of them, and then really ask and work with the lawyers. Typically, the lawyers are very good. They have their own incentives, but they'll work with you as a judge to figure out solutions to this.
Jim, Jodi, asking about your best practices, what you try to do early and often.
Yeah, I can jump in really quick. I think one of the things that I talked about earlier is cooperation with the other side, raising issues early, meeting and conferring, really important to build those relationships and trust with opposing counsel. Second thing would be, we sort of look at if we're making a redaction, as the judge indicated, you want a certain portion of a document to be not publicly available. Do you draw a big giant black box around it and say redacted, or do you present it in a different way that's more visually appealing to a jury? Again, just sort of subtle things that you can do. The information is still not being shown. It's just the perception of how it's being presented. And Judge raised a great point. Oftentimes in these motions that get filed, it's got a line in it that says a party can't file anything under seal. Has to file everything under seal that is marked as confidential. But the opposition, the receiving party, has no idea of why that information is confidential, and working together to build in appropriate time for the producing party to put that evidence together so that, the judge has what he or she needs in order to make those decisions. They're done on a timely, orderly basis so the judge can make a quick decision about confidentiality, and it doesn't linger for months and months, but that each party has a reasonable opportunity and appropriate time to make them. I think those are the things that I would focus, with training an associate in our firm, and things to think about are, cooperation. What does it look like visually when you're asking the court to do this? Are you prepared? Did you highlight? Do you have a judge's copy so that it's easy for the court? And then just thinking about, what the ultimate effect is, making sure you didn't miss anything, double and triple check, so that nothing that's confidential gets out unless the court rules it that way.
Yeah, I think those are all great points. I would say it's important always for both the press and for litigants and courts too, I would imagine, to not just focus on the fact that it's in a national security case, for instance, if you just hear national security and think everything has to be sealed, that's not really how those cases have been litigated historically. And there is usually going to be an ability to, even if it's like a bifurcated hearing where 90% of it is in public, but then the parts that actually do reveal national security information are not. Like they've litigated cases about things like atomic secrets and Pentagon Papers cases and numerous others that do involve national security issues, but that doesn't necessarily mean you have to spill national security secrets themselves in the courtroom. And so I think it's important and really could save, some unnecessary motions practice, frankly, if litigants more often took a more, and I realize it's a time consuming, nobody wants to be the one who has to go through hundreds of pages of documents and figure out which ones can we really live with being out there versus which ones need to be redacted. But that might have to be done at some point in some cases. And it is additional work, but it's work that is done, to have a public system. And honestly, it's easier for the press too if we don't have to file a lot of access motions. We don't want to file tons of motions to unseal. It's, we'll do it when we need to, but we would prefer not to incur that expense. So the more, the kinds of practices, that we're talking about in this panel, the more we can get out in front of these issues. There will still, I'm sure, be situations where the parties don't agree or the court, issues a ruling that the press doesn't think goes far enough. That's always going to happen. But I think in a lot of cases that could be avoided or the scope of it could be minimized.
I have a last question for all of you, but I'm going to put the judge on the spot first. One of the things that really galls me as a reporter is when judges conduct a lot of business in their chambers. And when everybody involved in the case is in the chambers but me, it raises a lot of questions in my mind. And so sometimes I'm sure there are legitimate reasons for that. And then other times with specific judges, it seems to be a lack of confidence or a desire to conduct business outside of scrutiny. And I just wonder, I wonder how, Judge, you decide when to do business in chambers and what kind of business that tends to be.
It's interesting. I've talked about this a lot with other judges around the country, and there's definitely different norms as you go regionally in terms of what does and doesn't happen in the courtroom versus in chambers. My sort of very simplistic dividing line is substance is in the courtroom and case management is in chambers. Right. So my initial case management conferences, now I may ask questions about the substance of the case, but I'm not having argument. I'm not making rulings. I'm just educating myself a little bit to make some file notes so I know what the case is all about. But what we're really talking about is scheduling and things like that. And it will often be, some lawyers saying to me, can I have 2 more weeks? Because I know my kid's going to graduate from college and that's going to be really hard to meet that. It's stuff like that that I don't think the public has any particular interest in hearing. And there's also, I mean, coupled with that, there's a certain degree of informality that is lost if I go up on the bench and put on my robe. And it makes it a little harder to have those conversations than it is if they're just sitting at a conference table in my chambers. So simplistically, I would say that is the line I draw. And then obviously the other part of it is settlement conversations, which just can't be done in public. And so, you know, if I'm having settlement conversations, which may be with both sides, sometimes parties agree to let me be the settlement judge as well, and to try and, you know, do some arm twisting. But even if it's with everybody, and I'm trying to get some sense of, you know, realistic assessment of the case, not advocacy, that's something that's got to happen behind the scenes. Those are the things that I think are on balance what I do. But it's interesting because when I raised that with some friends of mine around the country, their reaction even to the idea that I'm doing the case management stuff in chambers is very negative. And they say, well, how can you do that? And what happens when a lawyer goes and, you know, files an affidavit that says that, you know, that's not what you said in chambers or something like that. I'm less worried about that risk, you know, but it, as I said, it varies around the country. I would hope that judges are avoiding any kind of substantive argument or substantive discussion that's not in the light of day in some way, because that's the stuff the public has an interest in scrutinizing, to understand, you know, just to understand why I'm doing what I'm doing. And you know, what I do is you know, it's subject to criticism, and you know, I have to expose myself that way to that criticism for everyone to have confidence in what I'm doing. You know, the rule of law is implied; it's not expressed, right? I mean, I always say to people like, I don't have an army to back me up, and yet I sometimes issue orders literally to someone who does have an army in the executive branch, and yet they do what I say. And so, you know, that requires, if nothing else, confidence in what I'm doing.
You, Judge Jim. Jodi, any thoughts about that before we move to audience questions?
I think that was well put. And can I just read one sentence from an opinion by Judge Easterbrook, Seventh Circuit case in 2006, where he basically says that. He says, what happens in the federal courts is presumptively open to public scrutiny. The political branches of government claim legitimacy by election, judges by reason. Any step that withdraws an element of the judicial process from public view makes the ensuing decision look more like fiat and requires rigorous justification. That was in a trade secret case where Judge Easterbrook acknowledged that it might be permissible to, you know, withhold the trade secret itself, but like the court in that case, which got overruled, had issued entire summary judgment opinions under seal. So I think that is the point where we've all tried to make, you know, throughout the hour, which is the public's confidence in this institution requires that it be able to monitor what's happening.
Yep, and I guess my final thought would be it's a balance, and that's a delicate balance that is, you know, laid at the feet of our judiciary, right? Those of us who, you know, Jim either wants access, or it could be me trying to prevent access. And it really is up to the court. That's why the function of our judiciary is just so important. And if I can, you know, impress anything, it's that judges work awfully hard. In my opinion, they've got a lot of varied cases and issues that come before them. And, you know, they really are trying to do their best to balance the interests of the litigants along with the interests to the public in these documents. They don't always get it right, but most of the time they do.
Thank you so much. That was an absolutely fantastic conversation. I think we're going to open up to questions, and I will defer to Denise about fielding those.
Well, Robert Becker has his hand raised, so why don't we go ahead there? You can unmute.
Okay, and yeah, just a couple of observations here. First, to the judge, on the in chambers thing, there are a distinction I think needs to be made, which is in chambers and in chambers off the record.
Yeah.
And I think if the record is there, you may have to make a decision not to unseal the transcript, but at least the record should be there in most of those things that aren't just scheduling.
I would just to respond to that. I mean, with one exception, I can't think of a reason to do things in chambers and on the record, right? If I'm doing it on the record, I may as well do it in the courtroom. The only reason to do it in chambers and on the record is occasionally, and this has happened only once or twice, where I have, something where I need to do a proceeding ex parte. So for example, an attorney is moving to withdraw and needs to disclose some client confidences or something like that. But otherwise, if I'm doing it on the record, it may as well just be in public.
Okay, I think there are judges who don't feel the way you do about that.
Yeah.
Another thing that's come up in this conversation is in the federal courts in just about every district that I'm familiar with, there is a checklist of things to do when filing documents. And that includes, if the document has sensitive information, filing 2 copies, one under seal, that's the complete document, and one that has been redacted to take out social security numbers, bank account numbers, whatever needs to be taken out. So there's a sanitized version that is public. And so in that case, situation, a lot of things should be public, at least at some level. And Carrie, I was for 9 years the guy who received your call when you were thrown out of a courtroom at the Reporters Committee. And so I have to say, this panel is made up of people who deal with courts that deal with these kinds of issues all the time. For people who are covering courts in East Cupcake, Iowa, they don't have that luxury. And one of the things that needs to be done is to educate judges about, at that level, about these issues, and how we go about as media and judges and lawyers doing that is a major thing that we should be doing. And Judge, I'd like to apologize. Loki and I did not come dressed for court today.
So you're speaking our language. That's why we're offering this program. And we'll turn to Ginny Leroux next. Ginny, go ahead and unmute.
Thank you, Denise. Can you hear me okay?
Yes, you sound great, as always.
Okay, great. Well, I just wanted to say to Judge Wolson, thank you for all your thoughts and being so thoughtful here. Do you share some of the concerns expressed publicly by judges in other districts? I'm out here in the Northern District of California with the First Amendment Coalition. Chief Judge Richard Seaborg said it's pernicious, the excessive sealing he sees in civil matters, especially between well-heeled litigants. He said in one order, going forward, don't give me sealing requests that are so, oh, my business will be impacted, I will turn it down. Judge William Alsup out here in the Northern District has issued orders that say things like, to tech litigants, the United States District Court is not a wholly owned subsidiary of either of your companies. If you wanted secrecy, go to arbitration. They have been raising the red flags publicly for many years about just the volume of sealing requests and abusing protective orders and things. Are you seeing that or hearing about that in your district or other districts?
Yeah, I mean, it's 100% true that there is a tendency on the part of some litigants, and again, I sympathize, right? I was in practice. I understand that the lawyers have clients, right? And the client's like, wait a minute, I don't want this out there. Why is this out there? It is hard. It's a burden on the courts to get, a motion that says, well, everything I have should be under seal. To Judge Seaborg's point, and he's right. I sort of said this in my tenor in writing sometimes a little different. But yeah, it can't be, oh, this will cause me competitive harm. I wrote an opinion where I said, look, courts cannot permit parties to yada, yada, yada their way to a showing of harm, right? You've got to be specific in telling me what the harm is if you're going to claim harm. And, there are things that I see where I just look at it and I shake my head all the time at, the person who files and says, here's our financial information. Our financial information is not public. Fine. I'm with you so far. And so therefore you should seal these records, which reveal my finances from 2008. And I go, wait a minute, what's going to happen if someone knows what your finances were in 2008? And if you have an answer, great, tell me. Okay. And I'm open to hearing that, but often the answer is, well, we just don't make it public. I think we see a lot of that. As I said, I take patent cases from the District of Delaware. It's an enormous problem there. It's the same reasoning and the same pool of companies that the judges in the Northern District of California are seeing. So yes, it's an ongoing problem. And I would say, we've been talking about this in many respects, a lot of what we're talking about is at least in the background civil litigation. Although Jim referenced, for instance, the Trump trial in New York and things like that. But it comes up an enormous amount in criminal cases. And the place where I find it particularly problematic is in sentencing. Because in sentencing, particularly in the federal system now, I have this sort of giant black box of discretion, right? So I have to calculate what the settlement guidelines are. I have to look and see what the statutory maximums and minimums are. But once I've done all that, and as long as I don't exceed the maximum or go below the minimum without a legal justification to do so, I have almost unfettered discretion to impose a sentence as long as I explain why I'm doing what I'm doing. But too often I get defendants who come in and say, well, here are the 3 reasons I want you to impose a sentence. It's maybe below the guidelines or, things like that. And it's often my health, my family situation, things like that. But by the way, that's really personal and put it under seal. And I said, well, wait a minute. I mean, my sentencing decisions, again, they have to be subject to scrutiny. And if all the reasons that I'm using for deviating from the sentencing guidelines are under seal, then no one can assess my sentencing decisions. And so I understand it stinks that as a defendant, you got to make this stuff public. But if you're asking me to exercise my discretion that way, and again, these aren't really legal judgments, these are just equitable judgments, and you're asking me to exercise my discretion, I think the public's got to know what it is you're basing the request on.
And our next question is from Annie Capetta. Annie, can you unmute?
Hi, yes. So I'm also with First Amendment Coalition, like Ms. Leroux, and I just wanted to ask if you thought that there's enough training, support, and resources for judges and clerks to be prepped to handle these public access issues, especially the more niche issues, because, like you said, Judge Wolson, it's kind of a unique issue where, the parties are briefing it, but neither party is representing the interest of the public access typically. So the, clerks who might be handling the issue aren't getting that briefing in favor of the public access. So I just wanted to know what your perspective on how we can support judges and clerks in that.
I mean, so I guess what I would say is, for judges in the federal system, I think there's a fair amount of awareness of these issues, consciousness. The clerks have to get educated on it, particularly if they're term clerks and coming out of law school. These issues aren't really discussed a whole heck of a lot in law schools. I gave a lecture this year at Harvard on it, and hopefully I'll have an opportunity to do so elsewhere as well. But I think the judges are aware of it, and we have pretty good resources. I think where it gets probably thornier, and I know there's some state court judges who are on this Zoom, or at least had registered from what I saw. I suspect that's harder, not because the judges aren't as attuned to the issues, but just because the dockets are orders of magnitude larger in a state court. And so I would think it's much harder to be attuned to and aware of the issues as they're coming up in your cases. If you have, extra zeros numbered at the end of your caseload numbers as a state court judge. I would just think that's a real challenge. I don't know if there's anything you can do to educate judges about that, because it's just a workload thing, more than anything else. I guess if you want to go to some legislature and ask them to provide more resources so judges can have the resources to deal with them, great. But, I think that, and every state court's structured differently. So, different courts may have different ways of channeling these issues. But I think that's probably, the workload issue is probably a bigger issue in my mind.
Thank you.
And so would anyone like to raise their hand? We have someone who's polite enough that doesn't want to take a second chance unless everyone else has had their first. I will say, as we're waiting for a second, I'm so grateful that this program is recorded, because some of the tips are themselves just what judges and clerks could use when thinking through these issues. All right, giving everyone a second, I'm going to turn back to Ginny.
Yes, to respond to a point Carrie made, and to pick up on Judge Wolson's point about state courts, I covered state courts around Arkansas, Tennessee, Florida, Louisiana, before I was dedicated to the rarefied air of the Northern District of California. And I will say, to your point, Carrie, about covering the secrecy, I did often include a line in articles if the courtroom was cleared at any point, or if my note to the judge didn't get there in time to object to the closing. And I did have a couple judges pull me aside and say, thank you for reminding me. In the moment, I was thinking about the CI and not about the common law right of access or something. So I will say I found it nothing but positive, at least to my face, when I pointed it out. And I also wanted to say, I just think so many of the judges, some of whom are here, who would call me before a hearing or trial to say, do you think I've set up enough seats? Do you think I've set up the overflow room, for enough hearings? Do you, to be collaborative proactively? And so I don't know if you guys have heard that in the other panels where judges would call me up and call up my colleagues to say, have we addressed the issues in advance so it's not a last minute workload thing for me to handle? So thanks for raising that, Carrie.
Without additional questions, what I'm going to do is thank the spectacularly smart, energetic, and often smiling faculty. What's up with that? People being civil, treating each other with respect and kindness, even when they disagree. It's my dream. It's my dream Friday afternoon. So grateful to all of you. So grateful to the audience for spending their time with Berkeley Judicial Institute today. I wanted to mention that Judge Marcia Krieger will hold the next in this series of programs about judges and the jury, an issue I know of great love for those on this panel. The mystery of the jury on August 2nd. We hope we might see you there. Thanks to all of you. Again, there are materials that are on the site. Justin has magically put in the link, the registration for the Mysteries of the Jury program. We hope we get to see some of you there. We're so grateful to all of you for spending this time today. Thank you.
Thank you.
Thanks, everybody.
Thank you.
Appreciate your time. Yes, thank you.